One of the tired little things you're going to hear me trot out a lot is that the Supreme Court does not take cases for your reasons, but for their reasons. The Supreme Court doesn't just pick an issue that they want to talk about, they look for a case that is going to make really good law. And in my experience, they particularly like to find situations that make I don't know how to say this, but kind of a wall on one side of things. So, for example, there was a case I talked about a few weeks ago that was about the right of students to protest inside of a high school and whether or not they had a First Amendment right to protest inside of a high school. And the case said that sometimes they do, sometimes they don't. But in that particular case, yes, they did. And the facts of that case were it was a completely silent protest. The students really didn't do anything. They didn't block hallways, they didn't interrupt classes, they didn't do anything. All they did was wear a plain black armband throughout the day. It couldn't have been kind of a less interruptive form of protest at all. It was a really simple, basic protest. And by saying, yes, this was absolutely 100% within their First Amendment rights, the court was able to kind of lay down one end of what is definitely within the First Amendment and then leave some flexibility for things that maybe are a little bit more questionable. But if they'd started somewhere in the middle, then there's going to be a whole lot more discussion to figure out. So they really like to look for these cases that are kind of on one end of the factual spectrum. So, while it is possible that the justices that decided not to take this case wanted to leave the lower court's decision in place, it's just as possible that they looked at this case and were like, we don't like these facts, and this isn't going to be a good decider case for us, and so we're moving on.